Welcome to the Law Offices of Chris M. Ingram podcast. Today, we are celebrating the success of our client Rohit because his EB-1 green card that we had been working on for quite a few months was finally approved.
Yeah.
Now Rohit and his family can call America their permanent home. Okay, let's talk about U.S. immigration. This fantastic news about Rohit's EB-1 Alien of Extraordinary Ability green card really gives us a perfect opportunity to take a deep dive into what this visa is all about and perhaps offer some insights for you listening.
Absolutely. Yeah, Rohit's success is a great illustration, really, of what's possible for individuals with truly exceptional abilities. The EB-1, it's a significant category. It allows those in STEM fields, the arts, education, business, or even athletics, people who have really reached the top of their game to seek permanent residency. And crucially, without needing an employer to sponsor them.
Right, that independence.
That independence is a key draw for so many.
It really is. It's about having sort of control over your own future here in the U.S. Now, it's worth noting the broader EB-1 category also covers outstanding professors and researchers and multinational executives and managers, too.
That's right. Different pathways within EB-1.
Exactly. But for this deep dive, we're specifically focusing on the Alien of Extraordinary Ability category, the EB-1A, as it's often called. Our aim today is to really unpack what this visa entails and, drawing from Rohit's experience, highlight some of the key aspects.
Okay, so let's get into the specifics then. The EB-1 Alien of Extraordinary Ability visa. It's classified as an employment-based first preference visa.
First preference, what does that mean in practice?
Well, that first preference designation is really important because it essentially means these are considered the most highly sought-after candidates. They're basically placed at the front of the line when it comes to available green cards. We're talking about people at the highest echelons of their professions.
Right, so the very top tier, people recognized in arts, sciences, education, business, athletics. And what makes the EB-1A particularly attractive, as we've touched upon, is that combination of prestige and flexibility. Unlike so many other paths to a green card, you don't necessarily need a job offer lined up and you don't need a U.S. employer to petition for you.
Exactly. That ability to self-petition, it's a game changer for many individuals who are, highly sought after globally. But, and this is the key part, to qualify, applicants must demonstrate sustained national or international acclaim and recognition in their field.
Sustained acclaim.
Okay. It's not just about being very, very skilled. It's about having a well-documented track record of extraordinary achievement that's really garnered widespread recognition.
Okay, so how does someone actually go about demonstrating this extraordinary ability? What kind of proof, what evidence does USCIS, U.S. Citizenship and Immigration Services look for?
Well, there are two primary ways to qualify. The first is maybe the most obvious evidence of a one-time major international achievement. Think Nobel Prize, an Olympic gold medal, that sort of thing.
Right, those are pretty clear indicators. Hard to argue with those.
Exactly. Universally acknowledged significance.
But I imagine for most people, their achievements, while extraordinary, might not be quite at that level of global singularity. What's the other path?
That's right. The much more common route involves meeting at least 3 out of 10 specific criteria established by USCIS. These criteria, they're designed to provide a framework, a way to evaluate extraordinary ability across a really diverse range of professions.
Okay, let's delve into these 10 criteria. I think this will give everyone listening a much clearer picture of the specific kinds of accomplishments that can support an EB-1A petition. Let's maybe start with the first one.
Okay, criteria number 1. This is evidence of receipt of lesser nationally or internationally recognized prizes or awards for excellence in the field of endeavor.
Lesser, meaning not quite a Nobel, but still significant.
Precisely. We're talking about significant awards within your specific industry or field. Things that demonstrate recognition by a broader community, even if they aren't, household names globally. So in tech, for instance, it could be a prestigious industry award. In academia, maybe a distinguished research prize. Recognition that signifies you're exceptional within your professional circle.
Got it. So validation from your professional community. What's the second criterion?
Criterion number 2 is evidence of membership in associations in the field, which demand outstanding achievement of their members.
Okay.
As judged by recognized national or international experts in their disciplines or fields.
Yeah.
So these aren't just any associations you pay dues to join.
Right. It needs to be selective.
Exactly. These are selective organizations where membership itself signifies a high level of accomplishment because the entry requirements are stringent, often based on peer recognition or significant contributions. It's professional societies where you have to be nominated or meet very high standards.
Okay, so it's like getting endorsed by the leading groups in your field. What about number 3?
The third one is evidence of published material about the alien in professional or major trade publications or other major media relating to the alien's work in the field.
So this isn't stuff you've written, but stuff written about you.
Correct. It's about when established publications or media outlets have recognized and actually reported on your achievements and contributions. It shows your work has garnered attention and is considered noteworthy by others, by independent sources.
Okay, that makes sense. Your impact is being noticed and documented. What's the 4th criterion?
Criteria number 4 is evidence of participation, either individually or on a panel, as a judge of the work of others in the same or an allied field of specialization.
Judging others.
Yeah, this demonstrates that you're considered such an expert in your field that you're actually asked to evaluate the work of your peers. This could be things like peer-reviewing journal submissions, judging competitions, serving on dissertation committees, or expert panels.
That definitely signals a high level of standing and expertise within the community. All right, what about the 5th criterion? This sounds like it could be a really key one.
It often is. Criterion number 5 is evidence of original scientific, scholarly, artistic, athletic, or business-related contributions of major significance to the field.
Major significance. That sounds important.
It is. This is about demonstrating that your work hasn't just been competent, but has had a substantial, tangible, and impactful influence. It's pushed the boundaries of knowledge or practice in your area.
So what kind of evidence works here?
Well, it could be things like patents you hold, especially if they're widely licensed or used. Or maybe evidence of widespread adoption of methodologies you developed. Testimonials from other leading experts detailing the impact of your contributions can also be very powerful. When USCIS looks at major significance, they really want to see concrete proof of how your work has genuinely made a difference in the field.
That makes perfect sense. It's not just doing good work, but work that has demonstrably shifted or significantly advanced the field itself. Okay, what's criterion number 6?
Number 6 is evidence of authorship of scholarly articles in professional or major trade publications or other major media. Now, this one is about your own contributions.
Right, your publications.
Exactly. It focuses on your contributions to the body of knowledge in your field through published work. And here, the quality and the reach, the prestige of the journals or publications where you've been published are important factors.
Okay, so actively adding to the knowledge base through recognized channels. What's number 7? Seems more specific.
It is. Criterion 7 is evidence of the display of the alien's work in artistic exhibitions or showcases. This is primarily for those in the arts.
Makes sense.
It demonstrates recognition through things like formal exhibitions in reputable galleries, museums, or other significant, well-regarded venues.
So for artists, getting your work shown in important places is key evidence. What about number 8?
Criterion number 8 is evidence of having performed in a leading or critical role for organizations or establishments that have a distinguished reputation.
Leading or critical role?
Yes. This demonstrates that you've held significant positions, not just any role, but one that was vital or influential within notable organizations in your field. It indicates your level of responsibility and impact within that organization.
So it suggests you're not just a participant, but someone whose contribution is really essential to the success or direction of a distinguished organization. Okay, criteria number 9. This one often generates interest, doesn't it? The salary one.
It does. Criterion number 9 is evidence of having commanded a high salary or other significantly high remuneration for services in relation to others in the field.
So money talks, essentially.
In a way, yes. It uses your earning power as a more objective indicator of your exceptional value and standing within your profession. It's about demonstrating that your skills and expertise command a salary or a compensation package that's significantly above the norm compared to your peers in the same field and geographical area.
Okay, so the market itself recognizes your extraordinary ability through high compensation. And finally, number 10.
The 10th criterion is evidence of commercial successes in the performing arts, as shown by box office receipts or record, cassette, compact disc, or video sales.
Specifically for performers.
Exactly. This uses tangible measures of commercial success, ticket sales, record sales, things like that, to indicate extraordinary talent and significant public recognition in the performing arts.
Okay, wow. That gives us a really comprehensive overview of those 10 criteria. It's interesting to see the different ways extraordinary ability can be shown across such varied fields. Now, let's talk about what happens once someone believes they meet at least 3 of these criteria. What's the actual application process like for the EB-1A?
Well, one of the most significant aspects, as we mentioned earlier, is that unlike many other employment-based green card categories, individuals applying under EB-1A can self-petition.
Right, the self-petitioning.
Yes. This means they can file Form I-140, which is the Immigrant Petition for Alien Worker, completely on their own behalf. They don't need a U.S. employer to act as the petitioner.
That really does underscore the independence this visa offers. Are there other advantages to pursuing the EB-1A route?
Yes, definitely several key advantages. Because EB-1A applicants are considered these top-tier candidates, their petitions often receive priority processing.
Faster processing.
Potentially, yes. It can lead to shorter processing times compared to other employment-based categories, particularly those that require the often lengthy and complex labor certification process through the Department of Labor. The EB-1A bypasses that step entirely.
That's a huge time saver.
It can be. The rigorous criteria and the requirement for national or international recognition also contribute to this prioritization.
Okay, shorter processing times, bypassing labor certification. And what about the ultimate outcome? What does approval lead to?
Ultimately, the EB-1A visa provides a direct pathway to obtaining permanent residency in the United States, the green card. Once the I-140 petition is approved, the individual, and importantly their spouse, and any unmarried children under the age of 21 can then apply for lawful permanent residence status. This allows them to live and work permanently anywhere in the U.S.
So it's really tailor-made for those individuals who have reached the peak of their careers and have a genuine desire to make the United States their permanent home and continue their high-impact work here. Now, let's maybe bring this discussion back down to earth a bit by looking at the real-world example of our client, Rohit, whose successful EB-1A journey we celebrated right at the beginning.
Yeah, Rohit's experience is a really compelling illustration of how the EB-1A can, facilitate the American dream for individuals with these extraordinary talents. Just to recap his background, born and raised in Uttar Pradesh, India, came to the U.S. back in 2015 to pursue his master's degree at Northeastern University. He's really excelled since then and is now a senior product manager technical at a leading cloud computing company up in Cambridge, Massachusetts, focusing on global cloud security products.
Impressive. And what were his main reasons, his motivations for wanting to settle permanently in the United States?
Well, for Rohit, it sounds like a combination of things. His deep passion for technology was a big part of it, coupled with recognizing the U.S. as just this global hub for tech innovation. Plus, he experienced firsthand the supportive environment here for career advancement, moving from a developer role up to senior product management. He also really valued the dynamic tech ecosystem and the diverse and inclusive culture he found here.
So, a strong belief in both the professional opportunities and the overall environment in the U.S. What was his immigration situation before he decided to pursue the EB-1A? Was he facing challenges?
Yes, like many highly skilled foreign professionals, Rohit was initially in the H-1B visa system. He had an approved I-140 under the EB-2 category, but the estimated wait time for his priority date, well, is over a decade.
Wow, over 10 years. That's a long time to wait in uncertainty.
Exactly. It created considerable uncertainty for his long-term plans and, of course, for his family's future here. Even working for a prominent company, that temporary nature of the H-1B status was a constant background concern. So the desire for long-term stability, for a clear, more direct path to permanent residency for his family, that really made the EB-1A a very clear and attractive choice for him.
It sounds like the EB-1A offered him a much more predictable and hopefully faster route. So what was his experience like actually working with our firm, the law offices of Chris M. Ingram, throughout this EB-1A process?
Rohit described his experience as exceptional, actually. He specifically mentioned the thorough initial review of his professional profile, which is always the crucial first step. Then, the detailed guidance he received on how to strategically align his achievements with those specific EB-1A criteria we just discussed, and the consistent feedback he got at every stage.
That constant communication sounds key.
Absolutely. He also highlighted the firm's meticulous research and evidence-gathering efforts. Collecting and presenting the evidence is critical, and he felt it was done in a way that really showcased his expertise and impact effectively. He particularly appreciated, he said, the valuable insights from the caseworkers, which helped ensure his accomplishments were presented in the most compelling way possible.
It really sounds like a close collaborative partnership. Were there any particular challenges Rohit faced maybe in gathering the evidence or framing it correctly for the application?
Yes, definitely. He mentioned one of the main challenges was precisely framing his achievements to directly address the specific requirements of the EB1A criteria as USCIS interprets them. It's not always straightforward.
Right, you have to speak their language, so to speak.
Exactly. He found the team's feedback invaluable in providing the necessary context, highlighting the most relevant aspects of his work, and really ensuring the evidence clearly demonstrated his extraordinary ability. The team also helped him streamline his presentation, focusing on core strengths and, importantly, omitting maybe less relevant details that could clutter the application.
That kind of tailored guidance in presenting the evidence must be so crucial. Okay, so after all that work, what was his reaction when he finally got the news, when he found out the EB1A was approved?
Yeah, he actually received the notification email while he was in the meeting. He said he initially couldn't believe it. He had to refresh the USCIS website multiple times just to confirm it was real.
I can only imagine.
As soon as the meeting ended, the very first thing he did was call his wife to share the news. He described the moment as just one of overwhelming joy, immense relief, and gratitude. Knowing all those efforts over many months had finally paid off. They're now, understandably, making plans to celebrate this huge milestone with their family and friends.
Oh, that feeling of relief and pure joy must be absolutely immense after navigating such a significant and often complex process. And based on that experience, would Rohit recommend the services of the law offices of Chris M. England to others who might be considering the EB1A path?
Absolutely, he said, without any hesitation. He specifically emphasized the firm's deep expertise in these specific EB1 cases, their unwavering professionalism, and their genuine dedication to achieving a positive outcome for their clients. He really valued the guidance, the meticulous preparation, the commitment to success, and just the consistent support he received throughout the whole process. He felt it made it significantly smoother and more efficient than it might have been otherwise. He's apparently already enthusiastically recommended the firm to his network.
That's fantastic to hear, truly. Rohit's journey really does highlight the life-changing potential of the EB1A for those who meet those stringent criteria. Now, maybe let's shift our focus slightly. Let's talk about some of the common mistakes, the pitfalls that can occur in EB1 visa applications. Mistakes that experienced immigration attorneys often help their clients steer clear of.
Yes, that's a really important point to cover. Because even for individuals who genuinely possess extraordinary abilities, the EB1 application process is incredibly intricate. Overlooking key details or misinterpreting requirements can, unfortunately, lead to frustrating delays or even denials. One very common pitfall is simply inadequate documentation.
Not as proof.
Essentially, yes. Failing to provide sufficient and compelling evidence to thoroughly support each of the specific EB1A criteria being claimed. Applicants sometimes underestimate the sheer depth and breadth of evidence needed to convincingly demonstrate that sustained national or international acclaim we talked about.
Okay, so it's not just about mentioning achievements, but providing really robust proof and context that clearly shows extraordinary ability. What's another frequent error you see?
Another common mistake is misunderstanding the criteria themselves. As we discussed earlier, the EB1 category has different subcategories, EB1A, B, and C, each with its own distinct requirements.
Right.
Confusing these requirements, maybe trying to use evidence more suited for an outstanding professor claim in an extraordinary ability case, for example, can lead to submitting irrelevant or insufficient documentation. You need to target the evidence correctly.
That really underscores the importance of having a crystal clear understanding of which specific EB1 category is being pursued and what its unique requirements are. What's next on the list of common missteps?
Poorly organized applications. This might sound basic, but it can significantly hinder the review process.
Presentation matters.
It really does. Immigration officers handle a huge volume of cases. A disorganized, confusing submission can make it incredibly difficult for them to efficiently locate and assess the evidence of eligibility. A clear, logically structured, and meticulously organized application is absolutely crucial for a smooth review. Tabs, indexes, clear labeling, it all helps.
So how the application is put together is almost as important as the content itself. What about just following the basic rules and instructions?
You'd be surprised how often this trips people up. Ignoring specific instructions issued by USCIS is another common pitfall. This can be anything from missing required forms, submitting incorrect filing fees, not following specific procedures for how documents should be submitted or translated.
Small things that can cause big problems.
Exactly. Such oversights can lead to significant delays,
Yeah.
requests for evidence RFEs, or even outright denial of the petition just on procedural grounds.
Wow. Okay, so attention to detail and meticulous adherence to USCIS guidelines are clearly essential. What about the applicant's own narrative, the story they tell?
That's where the lack of a strong and persuasive personal statement or cover letter often becomes an issue. While all that documentary evidence is absolutely critical, the personal statement is the applicant's opportunity to tie it all together. It lets them articulate their achievements, explain why they are significant within their field, and clearly demonstrate how they meet the specific criteria for extraordinary ability. A weak, poorly written, or generic statement can fail to connect the dots for the USCIS officer reading the file.
So it's really the applicant's chance to weave together all the evidence and make that compelling case directly.
Okay, and what's the final common mistake you often see people make?
Finally, overlooking crucial deadlines and timing considerations can create serious problems. The process of gathering extensive documentation, especially things like letters of recommendation from experts, and then responding to any potential requests from USCIS, all of this takes time, often more time than people anticipate.
Right, it's not an overnight process. Not at all. Failing to adequately plan for these timelines can lead to missing potential priority dates if applicable, or result in rushed, potentially incomplete submissions, which obviously increases the risk of issues.
These insights into common mistakes are incredibly valuable, I think, for anyone even considering the EB1 route. Given all these potential complexities and pitfalls we've just discussed, why is it so strongly recommended to seek the help of an experienced immigration attorney, one with a really proven track record, specifically in EB1 cases?
Well, engaging an experienced immigration attorney who genuinely specializes in EB1 petitions offers numerous, really critical advantages. First and foremost is just expert guidance and strategic advice. These attorneys possess an in-depth, nuanced understanding of the intricate immigration laws and the specific, often unwritten expectations surrounding EB1 requirements. They can provide invaluable strategic counsel on how to best present your unique qualifications and build the absolute strongest possible case.
And you mentioned specialization.
Yes. As we touched on earlier, it's always wise to specifically inquire about a firm's experience and specialization in EB1 cases. Not all immigration attorneys handle these complex cases regularly.
That makes perfect sense. You really want someone who lives and breathes this specific area of law. What other benefits does that experienced attorney bring to the table?
They can develop a highly customized and tailored application strategy. Every applicant is unique, right? Their background, their accomplishments, the specific criteria they meet most strongly. An experienced attorney knows how to tailor the application to highlight the most compelling aspects of your specific profile and present them in a clear, persuasive manner that resonates with the immigration officers reviewing the case. They know how to frame your unique information in the standard, easily reviewable format USCIS prefers.
So they're skilled at telling your individual story effectively, but within that necessary framework that USCIS understands and expects. And crucially, how do they help in avoiding those common mistakes we just went through?
This is a huge benefit. Attorneys with a strong, proven history of successful EB1 cases are intimately familiar with all those common pitfalls we discussed, and they have the expertise to proactively avoid them from the outset. They ensure that your application is meticulously prepared, comprehensively documented, logically organized, and fully compliant with all current USCIS regulations and guidelines. Their experience, like, for instance, our firm's experience handling thousands of EB1 cases over 2 decades, provides a deep, evolving understanding of USCIS expectations and the subtle trends in how these cases are adjudicated.
That kind of long-standing, focused experience must be absolutely invaluable in navigating the process successfully. But what happens if, despite all that careful preparation, the application still faces challenges, like a request for evidence, an RFE, or maybe even a notice of intent to deny, an NOI?
Right, and that can happen. This is precisely where having seasoned legal counsel becomes absolutely critical. Experienced attorneys have the expertise to, first, carefully analyze the reasons behind the RFE, or NOI lead. What specific concerns does USCIS have? And then, they know how to craft well-reasoned, compelling responses, providing any necessary additional evidence or legal arguments to directly address those concerns.
It's not just about sending more paper, is it?
No, absolutely not. It's about a targeted strategic response. And it's important for applicants to remember even seemingly strong cases can sometimes receive these kinds of inquiries. The adjudication of EB-1s can be subjective. An experienced attorney not only knows how to formulate an effective response, clearly articulating the issues and providing the required information, but they also provide invaluable support and reassurance to clients during what can be, frankly, a very stressful and anxious time.
Yeah, I can imagine. It sounds like they act as both sharp legal advocates and also a crucial source of emotional support and guidance throughout that potentially challenging phase. What about the overall stress and anxiety associated with such a high-stakes application from the very beginning?
Well, that leads directly to another significant benefit: peace of mind. Let's be honest. Navigating the complexities of the EB-1 application process entirely on your own can be incredibly overwhelming and stressful. Knowing that you have a reputable and experienced attorney managing your case provides a tremendous sense of reassurance. Confidence that your application is in capable hands and is being handled with the utmost care, diligence, and expertise. Given the intricacies and the high stakes involved in EB-1 cases, it's generally just not advisable to attempt it without qualified legal representation. Following your attorney's lead and guidance throughout the process is really paramount.
That peace of mind alone must be worth a great deal to applicants going through this intense process. And ultimately, when you boil it all down, what is the most significant advantage of having experienced legal representation when you're pursuing an EB-1 visa?
At the end of the day, engaging a competent and experienced immigration attorney significantly enhances your likelihood of success. It's that simple. Their deep understanding of the law, their strategic guidance in presenting your case, their meticulous preparation, and their ability to effectively advocate on your behalf, all of these factors greatly increase the chances of achieving that positive outcome, that approval.
So while the EB-1 visa offers this really extraordinary opportunity for individuals who truly are at the top of their fields, it's abundantly clear that navigating the application process successfully, efficiently, and with less stress often requires the specialized knowledge and expertise of experienced legal professionals.
Absolutely. And success stories like Rohit's, they really demonstrate what is achievable. They underscore the immense value of having the right legal support throughout that entire journey. It's always incredibly rewarding to be the one to share the news of an EB-1 approval with our clients, making that call.
I bet it is. It certainly is rewarding on our end, too. Okay, that's all for this Let's Talk U.S. Immigration podcast. We hope you got a lot out of this presentation. Feel free to leave us a comment so we can hear from you. Thank you, Rohit, for sharing your journey with us. May we take this opportunity to wish you every success in your American dream. It has been a pleasure working with you.